under God, indivisible, with liberty and justice for all.
Roll call, please. Here.
Here, Cal certainly here, right here, the newsletter.
Here.
No. Okay, we have a quorum. We have minutes from June 9th. Any additions or corrections? We have a motion to approve. Motion. Second. And a second. All in favor say aye.
Aye.
Any opposed? Motion carries. First item of new business is case 6220 MSV. Who's handling that?
Zoning case 6220-MSV has been continued to August 4th.
Okay, so we don't need to take action on that? All right. Next item, case 6239 MV3. You got that one also?
Thanks, Chairman. Zoning case 6239-MV3 takes place in Joliet Township. The applicant is requesting a map amendment from C2 to C3, as well as 3 variances that will bring the property into compliance with C3 lot standards. The requested variances for front yard and side yard setbacks have been approved by the Planning and Zoning Commission. The purpose of the map amendment request is to allow for used car sales. Please note that the zoning case is evaluating the requested C3 map amendment, not the specific proposed business. The subject property is located on the northeast corner of East Washington Street and Park Road. The area is a commercial corridor within a residential neighborhood. Uses in the area include a tavern, car wash, general store, and phone store. The subject property is currently zoned C2. Zoning classifications in the general area include C2, C1, and R5. The nearest C3 zoning is approximately 1/2 mile south of the subject property. It is staff's professional opinion that the requested map amendment complies with Will County zoning ordinance review criteria. Staff recommends approval of the map amendment from C2 to C3. Planning and Zoning Commission voted 7-0 to approve the map amendment as well. That concludes staff's analysis.
Thank you. Any questions by committee? Are there any objectors to this change? Okay, could we have a motion to approve the variance or the amendment from C2 to C3? A motion by Steve, second by Ray. All in favor say aye.
Aye.
Any opposed? Motion carries. Do we need to do the variances or no?
They've already been approved.
Okay. Okay, item 3, case 6240, SV2. And this is in Plainfield Township. Natalie, you have that also?
Yes, thank you, Chairman Weigel. As you mentioned, the subject property for zoning case 6240-SV2 is located in Plainfield Township. The applicant has requested a special use permit for a drive-through facility as well as 2 variances. The variances were approved by Planning and Zoning Commission. The property is located at the southwest corner of I-55 and Route 30, east of Spangler Road. A gas station currently exists on the property and has been operating as a mobile gas station since 1991. The proposed drive-through will be placed in the rear of the gas station structure along the land use buffer, which currently exists between single-family residences and the subject property. The land use buffer is up to code and includes a fence as well as mature trees. The property is currently zoned C2. Northwest of the property is A1 vacant land. Northeast of the property is City of Joliet, B3 general business zoning. To the southwest is R3 single family residential. And to the southeast is public right-of-way along South Frontage Road. Staff recommends approval of the special use permit with 2 conditions. Condition 1, operating hours of the drive-through facility shall be limited from 6 a.m. to 8 p.m. Condition 2, adequate directional signs must be installed at entrances to guide drive-through traffic. Directional signage must be in compliance with section 155-13.30-B of the Will County zoning ordinance. The Planning and Zoning Commission also recommended approval with a 7-0 vote last night. That concludes staff's analysis.
Thank you. Any questions by committee? Any objectors to this change? Okay, could we have a motion to approve the special use permit for drive-through? Motion by Steve, second by Lauren. All in favor say aye.
Aye.
Any opposed? Motion carries. Do we need to do the variances or no? Okay, the PCC did that. Next item, case 6242M. This is the map amendment from A1 to I1 in Plainfield. Natalie?
Thank you. As you mentioned, the subject property is located in Plainfield Township. The applicant is requesting a map amendment from A1 to I1. The purpose of the request is to allow for manufacturing and industrial services limited. Please note the zoning case is evaluating the map amendment and not the specific proposed business. The subject property is a triangular parcel bound by Route 126 and 143rd Street. It is approximately 2.3 acres in size. It is located in an area dominated by open space. Abandoned strip mines to the north are in use by the Bass and Gill Club. The Deer Creek Recreational Club operates south and southwest of the subject property as well. West across 126 is the Penland subdivision, which is comprised of single-family residences. The subject property is a corner lot and only directly abuts the Bass and Gill Club to the north. All other existing uses are conducted across Route 126 or 143rd Street. The subject property is currently zoned A1. Abutting property consists of A1 and R3 zoning districts. R3 zoned parcels exist across Route 126 to the west. I3 zoning is approximately 500 feet south of the subject property. Approximately a half-mile east of the property exists I2 zoning. Staff finds that more intense industrial I3 zoning occurs within 500 feet of the subject property. More intense industrial I2 zoning occurs within 1/2 mile east of the subject property. The R3 zone property to the southwest is separated from the subject property by Route 126. The property currently exists as an illegal, non-conforming A1 zone parcel. A map amendment to I1 will create a legal conforming parcel. And the Will County Land Resource Management Plan supports high-quality industrial zoning for the area within which the subject property is located. Staff recommends approval for the requested map amendment from A1 to I1. The Planning and Zoning Commission recommended approval at the June 16th meeting as well. That concludes staff's analysis.
Any questions by committee? Any objectors to this change? We have a motion to approve. Motion by Steve, second by Ray. All in favor say aye.
Aye.
Any opposed? Motion carried. Next case, 6244 V3. Natalie, is this your motion?
Thank you, Chairman Michael. The subject property for zoning case 6244-V2 is located in Frankfort Township. The applicant is requesting a variance for cell tower height from 75 feet to 105 feet, as well as a variance for lot area from 2 acres to 38,459.5 square feet. The purpose of this request is to allow for the construction of a cell phone tower. This case requires county board approval. The Village of Frankfort has requested the case be continued in order to allow for more time for village staff to review the request. Please refer to the provided memo for more details. The subject property is located south of Lincoln Highway and west of South Hillside Road. The surrounding area includes business and residential uses. The nearest residential structure is approximately 300 feet from the proposed tower to the southeast. The subject property is vacant with an access drive to Lincoln Highway. It is zone R2 and abuts R2 zoning to the east. West and south of the property is incorporated parcels with the Village of Frankfort. A business is located on these incorporated parcels. North of the subject property across Lincoln Highway is zone C1. The proposed lease parcel will be along the western property. The proposed cell tower will be constructed in the southwest corner of the lease parcel. It is staff's professional opinion that the requested variants meet the Will County Zoning Ordinance review criteria, as well as wireless telecommunication review criteria for state statute. Staff recommends approval of variance for cell tower height from 75 feet to 105 feet, and for a variance for lot area from 2 acres to 38,459.5 square feet. The Planning and Zoning Commission recommended denial of variances with a 1-6 vote. That concludes staff's analysis.
Thank you. Any questions by committee?
Do you know the reasons why they denied it?
There was, opposition from residents in the neighborhood. I believe that affected the plan commission's vote.
Steve?
Was there any permits pulled for like what they're gonna do with the fill? You know, all the leftover dirt and stuff?
Not that I'm
left on
aware
the
of.
property?
We will need to check with our engineering staff to confirm that.
Before we continue comments, are we going to hear from the public?
Yeah.
Yeah. Okay. I'm going to reserve my comments till after we hear from them.
Okay. Is there anyone from the public who would like to comment on this? Well, okay, if you'd come down to the podium one at a time. State your name, please.
Tammy Frenzel. I don't know if this is on.
Check at the bottom of that stick, there might be a switch.
Okay. It's better.
Okay, go ahead.
Okay, I've been living in Lincoln Estates for 20 plus years. My house this would practically be in my backyard, this tower. A house is usually your biggest investment. I strongly object to this tower idea. I know I speak for all of us as residents. Also, may I add, we were not sent notice of this. And I know it's been planned for a while now, it's obvious. There are plenty of other areas for this, like less than a mile down on Route 30 towards LaGrange. There's a huge field. Plopping it down in the middle of us residents is ludicrous. This whole thing is sneaky and shady. This tiny sign on Route 30, which is a 4-lane highway, is going 45 miles per hour, doesn't cut it. Also, it was improperly placed. Do the math. It's not the fact that they are able to plop these things wherever legally. It's the fact that we don't want it. And I'm sorry, but I'm not going to trust the cell phone corporation with our health. We are not idiots here. What about our property values too? They could care less. It's all about revenue, let's face the facts. It's an obvious eyesore, an obnoxious eyesore. In closing, would you want this in your backyard? It's very unfair to us, and I will continue to inform my neighbors.
Thank you. Any questions by committee? Okay, thank you. Next person. State your name, please.
Patrick Frenzel. Tammy's my wife. The cell phone tower will be an adjacent property to our house. I'm very well aware that the cell phone company has stated there's federal studies that there's safety with radiation from these towers. However, I have a major in biology, a minor in chemistry, and a doctor of podiatric medicine. I'm very well aware of studies. Sorry, I didn't get to prepare well because of the short notice. And I understand when a company sponsors certain studies, the results could be skewed. I heard that one gentleman had said that there's more radiation from a microwave oven. Well, I don't leave it on for 24 hours a day, 7 days a week. So what is the cumulative effect of the radiation over, say, 10 years or 20 years? There are small children living within the area of this tower. It just does not make any sense to me. There's plenty of, besides down Route 30, there's other unincorporated areas just south of us where a tower can be put up without any residents in the area. As far as safety of the tower, what if there was a natural disaster, like a tornado? Is it going to knock down a tower? It's going to go right over Lincoln Highway or on someone's house? Or it could be in a field somewhere where if something were to happen, it falls onto a field with no danger to any residents in the area. These are my objections to it, besides the very blatant way that they were trying to sneak this through without anyone noticing it. I know that they probably follow certain legal protocols, but I mean, really, got to be other areas that we can put this. That's all.
Any questions by committee? Okay. Any other? Okay, come forward, please. State your name, please. You represent the cell tower?
Yes, I
company?
do. My name is Bob Stapleton. I live at 1900 West Acre Road here in Joliet, Illinois. I am president of National Wireless Ventures. And I'm also here on behalf of the applicant, Horvath Communications, and T-Mobile. There was a lot of statements made that were made last night, and a lot of things that I want to correct. First of all, the neighbors were all talking about the fact of work done prior on the property that was done regarding grading, filling, things like that. Christopher Burke, who happens to be the owner of the property, is well enhanced in the engineering world. Christopher Burke would not do something that would be illegal, would be doing in accordance. And in fact, if everything, they filed all the proper paperwork with the county, with the federal government, and everything concerning the filling of the property and everything else. They have long-term intentions of basically bringing the parcels together. They own the adjoining parcels through other companies. Yeah, they're currently meeting with Frankfurt today to de-annex that Frankfurt-owned property to bring into the county because they have a long-term plan in developing for their business. Also, I understand the testimony regarding health issues and things like that. The federal government is responsible for the issuance of the spectrum, issuance of the power, and the issuance of everything else regarding to wireless communication. And the federal government has made it very clear that health issues should not be weighed in the determination regarding the granting or not granting of a cell tower. As I explained to the commission last night, the state of Illinois is going through basically deregulating the telecommunication industry, meaning the traditional landline people. As we switch over from landline to wireline, additional services have to be made. Give you, for instance, over 400 million transmissions between devices and cell towers have occurred, within the last year. 400 million, that's an amazing number. The industry is talking about we're going to close to 10 billion instruments within the next year that'll be communicating wirelessly for service. So because of the lack of service from the standpoint of folks disconnecting from their wireline service, needing wireless services within their home, I mean, the basic design for this tower is to supply additional wireless services for the home, additional 911 capabilities, because the federal government has basically said we need to find people when they dial 911 on their phone. Over 91% of 911 communications go through wireless devices. And so it's imperative that we have sufficient service. And at the same time, there was discussion about a generator. The federal government is pushing to hardening the wireless sites. Why? Because in the event of something catastrophic like what just occurred down in Coal City, that the cell towers are in place. We stayed intact for Washington, the Washington County tornado. We stayed intact just now for the Coal City. We stayed intact when it occurred out in western Illinois. Emergency calls immediately placed on wireless devices came through those towers, and that's the service that we're providing. So we feel that based on staff's recommendation, this is an appropriate spot to enhance coverage, and we've shown the reasons why we need it. Is we don't go out and make an investment of $400,000 for the purposes of just putting something in the ground. We make the investment because the service is needed, and that's what we're providing. Thank you.
Thank you. Any questions by committee?
I have a question. I just want to get clarified. Did you say the federal government says we should not take health concerns into consideration? Could you clarify that?
Yeah, it's under the, I'll let your attorney speak.
Thank you for bringing that issue up, Chairman Weigel. I did do a little research into this area, and I'm glad that question was raised. I believe the applicant is correct in regards to what the Telecommunications Act provides. Excuse me. that the environmental effects, including the health concerns and the biological effects, are expressly prohibited to be considered by a local zoning board such as this in granting or denying the application. However, there is also case law out there that indicates that the mere fact that members of the community raise health concerns does not in and of itself violate the Telecommunications Act. It's when the TCA, the Telecommunications Act, is violated when the zoning board's denial of an application is based in part on those concerns. So hopefully that clarifies your question.
Thank you.
It does, thank you.
And last night, we did provide testimony. The American Cancer Society, the World Health Organization have all stated that they do not see any effect on health issues regarding the placement of wireless towers and hand devices.
Okay, thank you. Any comments by committee? Any other one like to speak? Come down to the podium, please. State your name, please.
Patrick Frenzel. I realize you cannot make a decision based upon health risks. I would just like to say that there's been multiple times that there's a consensus on health that has been turned over. How many times have we heard that eggs are unhealthy, then they're healthy, then they're unhealthy? Besides that, my neighbor had a good complaint since his house is 300 feet from where this will be built, is that as far as having a generator built with noise variances and pollution, it still does not address, even though the towers did not come down in Coal City, structural damage that could happen if this tower were to come down. I just wanted to say that as just a side note as far as the health issue on that.
Thank you. Okay, any questions by committee?
I have a few questions. I did not see in the packet an actual outline of where this was going to go on the property. Is it in the southern end, the southwest, southeast?
They provided the plat of survey.
Yeah, I got that, but I didn't see where it actually says.
So the lease parcel is on the western property boundary.
Okay.
Depending on how you look at that plat of survey, I believe that's at the top of the page.
Okay.
It's a square. The cell phone tower will be placed at the south.
So they're going to be on 6203, basically?
They're on the western property line.
6201 and then 6203 on the western property line?
They're still going to be on the parcel that's indicated for the zoning case.
Right. If this were to fall over, is the entire fall zone located within the subject property?
Staff evaluated the fall zone for 105 and came to the conclusion that there would not be any structures within that fall zone because the tower will be towards the east of that leasehold parcel.
Okay, but would it all fall on the subject property? In other words, the 105 foot, if it tipped over, would it stay on the subject property or would it encroach on surrounding properties?
It would encroach on surrounding properties.
Okay. As far as the deviation from 2 acres down to 3/4 of an acre, 0.8 of an acre, I believe it is, less than an acre. I personally don't like telling individuals what they can and can't do on their property. I'm a very strong property rights individual if someone wanted to come forward to build something on their property. However, I do believe that there are laws in place that protect individuals that are in the surrounding properties. In this case, right in the middle of a residential area, they're asking to put a tower that's taller than the minimum, and they're asking for us to change the minimums from 2 acres down to less than an acre. If we looked at the state statutes and the compiled statutes, I don't believe anywhere is there even an allowable tower by the state of Illinois or by the federal government in a property that's less than an acre? I know right now if it's 2 acres, it's 75 feet. If it's A1, it's above 10 acres, you know, they can go 200 feet. But I'm curious to know, is there even a possibility of being able to grant a tower in a property that's less than 1 acre currently?
The zoning ordinance requires a minimum of 2 acres with regard to the residentially zoned property. So in this particular instance, necessitates variance.
But that's what I thought, and for that reason, that is why I'll be voting no.
Any other comments? Okay, we'll take a vote on it. Make a motion to approve the variance from 75 feet to 105 feet. Motion.
I'll make the motion so we can vote on it.
Motion by Steve,
Second.
Second. Have a roll call, please.
Denise Winfrey,
No.
Judy Ogala,
No.
Steve Ballage.
No.
Ray Timonella.
No.
Ron Staley Perry,
No.
Chairman Michael.
No. Okay, there's a variance of 2 acres to 38,000 square feet. Motion by Winfrey, second by Warren. Roll call, please.
Denise Winfrey,
No.
Judy Ogala,
No.
Steve Ballage,
No.
Ray Timonella.
No.
Ron Staley Perry,
No.
Chairman Michael.
No. Okay, they're both motions are denied. Does this go to the county board? David?
Yes.
It goes to the county board next week for their approval or denial. Next case, 6253S, special use permit for cup sales in Naperville. Kimberly?
Thank you. Good morning, committee members. Zoning case 6253-S takes place in Wheatland Township. The applicant requests a special use permit for light equipment sales and rentals. The purpose is to allow the sales and rentals of recreational vehicles. The parcel is 9.39 acres, and boat sales previously occurred on the property. The general location is south side of Route 59, north of 103rd. The current zoning is I-1. The surrounding property, the abutting is industrial, also unincorporated, but surrounding on the west, south, and east is incorporated city of Naperville. The applicant proposes to remove a building in full repair and proposes to construct a new addition. There are conditions attached. Staff recommends approval of a special use permit for light equipment, sales, and rentals. Planning and zoning recommended approval with a 7-0 vote. This concludes staff analysis.
Thank you. Any questions by committee? Any objectors to this change? Okay, we have a motion to approve. Motion by Steve. Second. All in favor say aye.
Aye.
Any opposed? Motion carries. Okay, other business? Zoning draft text amendments for mural art and craft breweries, truck terminal.
Good morning. What I'd like to do is consider each of these individually and then have the committee take a vote on each one individually to whether or not they would transmit the text amendment to the board for consideration this month. With the first text amendment, craft breweries and distilleries. This is considered a public hearing last night. There were no members of the public in attendance for any comments on the matter. The commission had comments to forward to the committee primarily with regard to the quantity of distilled spirits for sampling and questioned whether or not a total quantity of 1 ounce of distilled spirits to any person in a single day was of a sufficient amount to allow for sampling. There was no particular recommendation for increasing that amount with with regard to, not impairing somebody on the road. This is not something we necessarily as a staff looked into with regard to particularly how many ounces of distilled spirits a person can consume a day without becoming impaired, because, a variety of different issues play in this as far as, how much a person consumes, their body weight, their tolerance, and things of that nature. What I can share with you, though, is that the amounts that are in the text amendment do mirror the Village of Oswego ordinance that they passed recently with regard to quantities. There's one potential business owner to whom this text was sent, and that individual did not have any comments on quantities as well. But it's up to the committee today if they feel that it might be necessary to increase the volume of distilled spirits, the maximum amount per day, whether that be 2 ounces, 3 ounces, 4 ounces. That'd be the prerogative of the committee.
Thank you. Any comments by committee?
I just wondered, depending on the day, maybe 12 ounces. Kinds of things that are going on. But, and I understand that, everybody's tolerance is different. But I wonder if we looked at, I know Oswego, but some of the places that have long since had tastings, what's common for those? Do we know that?
I did not go beyond the Village of Oswego. I know that the gentleman that was interested in opening the business in the county had cited the Village of Oswego as an example. And so I just went to that ordinance and looked at that and mirrored that since it was a local jurisdiction.
Okay, and then at Shorewood, wine styles, I think it's called. They have tastings all the time. I don't know what the limit is there either. Right on 59, so that's really our jurisdiction. So wine styles it's called. So I don't know if that might be helpful to know.
When we're going to start talking about that, I think that's a personal choice of how much you're going to consume. And I don't think it's a place for government to get involved in. And if a person wants to go overboard, it's up their prerogative, and they're going to face the consequences if they drive. But for us to say a certain number, I think that's wrong.
That would be the committee's prerogative today as well. If you desire to remove the quantities from lines 8, 9, and 10, you guys could do that as well.
Yeah, I would really like us to go beyond the Village of Oswego, go to an area where they do this more typically, maybe a tourist area, something like that, to see what limits there are. If I were to go in and I wanted to buy some sort of spirit, and I wanted to try this one and this one, maybe an ounce isn't enough to try it, to get a taste of it. I, like Denise said, sometimes need 12 ounces too. So, but not that I would go there and taste it. So, but the thing is when you're tasting, I don't know how many spirits they'd be offering, and 1 ounce is pretty small. So, I don't know. Maybe we could look at that to see what an area that does this more frequently, probably an area that has a big visitor area that they do this. If we could look into that before we limit that.
Steve?
If you go to any of these major liquor stores on a Saturday, you can sample vodka for 2 hours walking around. You can sample every beer that they sell on certain days, not every day. They have whiskey sampling, and nobody limits you, nobody pays attention to anything. But I think this is kind of one of those things, it's not our business, just leave it alone.
We're not going to be able to police it anyway. Why don't we just remove the amount from the ordinance?
I agree.
Let it up to the proprietor what they feel they want to do with it.
Right.
They're not going to give away the gallon of wine to somebody anyway. So.
No.
Okay.
Just one other question. Is the limit for total dispensing, or is it, most of those places they have in those little shot cups. So we're not trying to say how many cups you can have. We're saying that the initial dispensing can only be so much at a time. Is that right?
Actually, the way this ordinance is constructed, as well as the villages, is it puts a maximum amount per day. So they could, for instance, with the beer, the 16 ounces could be, split up into different quantities.
Right.
It's just a maximum of 16 ounces per day.
Okay.
And the 1 ounce per day for distilled spirits.
Okay, I don't see how we would manage that, but we could say you can't dispense it in more than these little cups at a time. So a person has to stand around all day trying to keep coming back to the tray, but how would you track who's had how much all day? That, you know, that's not
And you couldn't really do it with those little cups either, because if you're having a beer and you put, where you can't even taste the damn thing.
Well, that would require that the
It's
person
not gonna
has
work.
to then, by
You know,
their
so
own will,
it
have
would work with
cup.
whiskey, but it wouldn't work with beer. And with wine, you'd want more than a little bitty bit. You know, I think it's not our business. Like Tom said, we should just remove it.
Yeah.
I didn't realize my colleagues were such alcohol connoisseurs. I must be hanging around with the wrong crowd, but the reality is, I believe that was put in there solely for a CYA on Oswego's part. And by pulling it out, that could have, you know, litigation ramifications in the future if someone were to go to these sampling events and just go crazy. And there was nothing that we had on the books. Now, yes, we can't police it. B, we have no way of knowing who was in violation or not. But at least in our ordinance, we would have something on the books that would actually protect us in the event there was something that did happen.
We can't be sued.
And I would say,
We're immune from suit in that type of case, so it wouldn't matter.
I'd say
We're not
I
going to
would
be
not
held
want us to
liable
get into a dram
by any
shop
of that, by
situation.
not having an ordinance.
So if we were, the initial dispensing is limited to a certain size cup, then after that, people are on their own. But in terms of a total for a day, you can't. So if, you know, if you're using those little Jell-O shot cups, whether people can taste it or not is their problem. But you start out, you say something in the ordinance that it cannot be dispensed in more than a certain size, which then gives us some coverage. However many people consume,
Well,
it's
again,
their
I think
problem.
that you maybe instead of saying a certain size cup, well, make it 4 ounce cup. You know, you might not like that, somebody else might not like it. So let's make it a 1/10 of an ounce cup. And then the guy that's dispensing it to try to get people to buy it says, well, they can't taste it, so they're not gonna buy it because they don't know what it tastes like. You know, so I mean, to come up with any of these numbers is ridiculous. And for us to think that we're gonna be sued, the county's immune from liability on this stuff. You know, and right now, when they do that, they have to have dram shop insurance and everything else in those establishments, and they're covered under their own insurance, and it's up to the owner of the establishment to figure out what kind of rules they want to make, because they're liable, not us. They're the ones that are really liable. And that's why I think we should just get rid of it.
You make that motion, Steve?
I'll make a motion to withdraw it.
To
Remove
remove the amount, right?
Remove, yeah.
Approve the ordinance with for distilling sample.
Yes.
Okay.
So-
Second?
I'll second so we can vote, but my question then is, your recommendation is that we remove all amounts in there?
Hold on. Before we do that, we better read it, because if you remove A, all sampling shall be in a designated on-site tasting room. I think that needs to stay. I would just eliminate and shall be after that, because we want to make sure that the sampling is done on-site in a designated area. And I think just eliminating the amounts.
Right, we're just eliminating the amount.
Right, not in the parking lot.
Okay, all in favor with the amendment, say aye.
Aye.
Aye. Any opposed?
Nay.
Motion? You got one?
Denise wants to pick up.
We need a roll call on it.
Apparently somebody does anyway. I would say.
We're voting on what, this amendment change now, or what?
Well, I guess we need to vote on the amendment first, to remove the amount.
So we're voting to remove the amount.
Right. Okay, roll call to remove the amount.
Denise Winfrey,
No.
Judy Ogawa,
Yes.
Steve Bowledge.
Yes.
Ray Manila,
Yes.
Lawrence Taylor Ferry,
Right.
Chairman Weigel.
Yes. Okay, then on the main motion with the amount removed, motion to approve by Steve, second by Ray. All in favor say aye.
Aye.
Any opposed? 1 no. What's the other one, Dave?
Okay, we have 2 more to go through. The second one is with regard to the truck terminal. And the text amendment that went to public hearing last night was considered at the commission. And again, there were no members of the public that commented. There was one commission member that inquired about whether or not there's any numbers or quantification of what would, of units on the property that would constitute a truck terminal, and there's not. It's specifically defined as a facility principally used for the parking, storage, dispatching, and maintenance or repair of trucks, truck tractors, and semi-trailers. Currently, the ordinance does not specifically define truck terminal. Then under the ordinance, what we do is then we go to Merriam-Webster's unabridged online for definition. There's no specific definition of truck terminal that meets the county's needs. And so then the third fallback is then an interpretation of the department. This definition is consistent with how the department has advised, interpreted and advised individuals since 2012 that have been required to apply for a special use permit. And so what this does now is that when somebody does ask the department, how do you define a truck terminal, we can provide the definition as being actually codified.
Okay, any questions by the we have a motion to approve?
Motion.
Motion by Judy, second by Steve. All in favor say aye.
Aye.
Any opposed? Motion carries.
Then the third text amendment before you again was considered last night in commission. This is with regard to interpretive murals. And as like the others, there were no members of the public to comment. There were no commission comments. What the text amendment does is it removes the interpretive mural provision from the government constitutional signs exemption under the ordinance. That initial text amendment was made a few years ago for interpretive murals that were placed on Route 30 by the state of Illinois. One of them is at the Frankfort Township building. And there is limited text on those interpretive murals. But what this does not do is address works of art or private interpretive murals on private property. And we've had one individual, more particularly specifically with regard to the property where the John Lane Monument is, that has had a desire to have a interpretive mural or a work of art that's created by a local artist placed on the side of her barn on the property. So again, what this does is that it removes the exemption of governmental institutional signs and makes modification to the definition of interpretive mural, and it speaks to it as a work of art. And it removes it from being required to be placed in the public domain, meaning on government property, but does limit it to 200 square feet, and again, basically says it cannot have a commercial message on the sign. It has to be truly interpretive if there's any text on there. So the net effect is that it would allow private property owners such as the owner of John Lane Monument property to retain, a local artist to create an interpretive mural and place on the side of her barn, as long as it does not exceed 200 square feet and does not contain a commercial message.
Thank you. Any questions by committee? We have a motion to approve.
Motion.
Motion by Steve, second by Ray. All in favor say aye.
Aye.
Any opposed? Motion carried.
Tom, I had a question about the murals. I like the, that's fine, but I had an email about, I guess you'd call it decorative art or murals. The guy, he has land, and I left the email at different meetings. I don't have my email with me, but evidently he has all this metal on his property, and he takes the metal and he welds it together and he makes decorative art out of it. Is that part of this, considered part of this, because he's used it as ornamentation for his property? When it's probably ugly to the neighbors, but it probably looks good to him. So I just want to know where we're standing on something like that. Are we telling people what they should consider art, or are we staying out of it, or what do we do?
this is not pertaining to the situation.
No, I know, but when we're talking about the murals, that's what.
With the mural specifically.
I was gonna ask that later, but.
What I'm trying to do is actually get us out of the business of telling people what they can and can't put on there.
I mean, this doesn't have to do with what we just passed. I was talking about, as long as it was kind of the thing, I figured I'd ask it now.
You know, I have to look in the ordinance, and I can't speak specifically to that situation, but generally, I have to look at the ordinance and see if it does specifically address a work of art. But typically, you know, when you get into situations such as that, it's more of a property maintenance issue, property maintenance code.
I mean, I don't know how much metal he's got on his property, but I know, you know, if he's got a big giant statue of metal, made out of metal with car parts welded together, it might not be attractive to me. But, you know, I know there was like a tree made out of junk cars in one of the shopping centers up north. And that was supposed to be like real beautiful, you know, and so art is, you know, I guess beauty's in the mind of the beholder. You know, just because I wouldn't like it doesn't mean it's not art. And I want to know where we stand, so if this guy emails me again, I can have a response.
I would suggest this, if you could forward that email to our office, and we can review it and then advise you accordingly.
Okay, thank you. The next item on the agenda, the Delaney Road map amendment is being removed. Third item is the Austin Walter Barn, historic landmark. Janine.
Thank you. Up before you today is the nomination of the Austin Walter Barn as a Will County landmark. The barn is located on the Trantina Farmstead at 15744 West 151st Street in Homer Township. And Homer Township is the owner of the property and they support the nomination. Staff found that the barn satisfies 5 of the 12 criteria required for designation as a Will County landmark. And those criteria are on the back of the sheet that I passed out to all of you. So for criteria 4A, the barn has character, interest, and value, which is part of the development and heritage of the local community. The Austin Walter Farmstead appears on the earliest map that we have of Homer Township in 1851, and the barn was built that very same decade. It represents the early rural agricultural beginnings of Homer Township. The barn remained on the Austin Walter Farmstead for 150 years until the property was purchased by Homer Township in 2000. The township and residents advocated for the preservation of the barn, which speaks to its importance in the local community. The barn was deconstructed and relocated to the Trantina Farmstead, where it was subsequently reconstructed in 2008. Criteria 4C, the barn is identified with a person who significantly contributed to the development of the community. The original owner of the barn was James Austin, who was an early settler. He arrived in Homer Township in 1838 and purchased the farmstead where the barn once stood in 1851. He was one of the first boat captains on the I&M Canal, a Civil War veteran, and he later served as Homer Township Highway Commissioner, School Director, and the Township Assessor. Criteria 4D, the Austin Walter Barn embodies distinguishing characteristics of an architectural style valuable for the study of a period, type, and method of construction. The barn is a typical 3-bay threshing barn that embodies the 1850s construction methods, which is extremely valuable in order to educate the public about the historic practices. It has hand-hewn beams, mortise and tenon construction, and hardwood pegs. It has no nails. Criteria 4I, the structure is a particularly fine example of a utilitarian structure with a high level of integrity, architectural significance, and historic importance. 3-bay threshing barns are a very common Midwestern barn style, but what allows the Austin Walter barn to stand out is its historic significance due to its age and its high level of integrity. The barn was expertly restored back to its 1850s appearance in 2008. Very few new or replacement materials were required to be added. And the final criteria, 4J, the property is suitable for preservation. The barn was obviously restored, but it's suitable for continued maintenance and preservation for the future. On July 1st, the Will County Historic Preservation Commission held a public hearing. Pam Myers, Homer Township Supervisor, Lindsay Sawa, Homer Township Clerk, and Tom Fejan, who is a member of the Homer Township Open Space Committee, were all present. Pam Myers spoke on behalf of the township and voiced the support of the township for the nomination of the barn. Following the conclusion of the public comments, the commission made a motion to recommend approval of the Austin Welter Barn landmark nomination, which passed unanimously. So today I'm asking for your approval of the nomination of the Austin Welter Barn as a Will County landmark so that it may be presented to the Will County Board for final approval. Thank you.
Thank you. Any comments by committee? Judy?
I just want to say I'm glad that they have done this with this barn because nobody builds old barns anymore. They all put up metal pole barns, so the character's not there, and it is definitely something to preserve for the future so kids can see it live versus just looking at a book at a picture. So I think that, and I know Pam Myers, she does a great job representing her area up there and her constituents, and so I'm really glad that they did choose to do this, so thank you for bringing it to us today.
Yeah, I was on the township board as a trustee when we went about getting this built, and it was a big effort by everybody in the community, and it was a real big expense too. And you know, I'd like to make sure it gets passed.
Motion
Second.
and second. All in favor say aye.
Aye.
Any opposed? Motion carries. Thank you. That concludes our business. Any public comment? Any comments by committee members? No, I have no comments. Director, any comments? We don't need an executive session. Motion to adjourn? Motion. Second. All in favor say aye.
Aye.
We're adjourned. Thank you.